Hello and welcome to House and Home Chat, Real Estate Real Talk with Dina and Chris. I'm Dina Mathis.
And I'm Chris Breitenbach. Hey, we are back today to talk a little bit about real estate and estate planning. We'll be chatting with Chad Levin. Chad is a partner with Heyman Law in Montgomery, and Chad leads that firm's business, estate planning, probate, and elder law practices. So we'll be chatting with him about estate planning, protecting your investment, and tackling some of those need-to-know facts.
And it's a really important topic that we frequently run into in selling real estate. And we're also going to be devoting the real talk portion of our program today to addressing a few questions that we've received from our listener audience. So we're happy to have Chad here today. Welcome. He'll be walking us through all of that. Chad, thanks for joining us.
Thank you for having me. I'm excited to be here.
Well, great. Hey, Chad, we always start our guests by having them introduce ourselves. Tell us a little bit about yourself.
I'd be happy to.
Okay.
I'm native of Cincinnati, grew up here, and after going away for college for a few years and living in New York, I came back and went to law school here at UC, and have been practicing in town ever since for about 27 years.
Well, we like the Bearcats, so hey, you're in.
Absolutely. And as you mentioned in the opening, I focus my practice in estate planning, probate, business, some real estate, and then elder law. So those are my primary areas. And go ahead.
Very well, much needed.
Yeah,
Yes.
for sure.
Yeah.
So let's just dive right in then and start with the estate planning. Tell us why this is an important thing for our listeners to know and to do.
Sure. Well, I mean, estate planning is basically getting your affairs in order for what's going to happen to your property when you die. So it involves wills, trusts, those types of documents. And it's important, I think, because we want to be able to have control over what happens to our property when we die, make sure it passes the way we want it to, make sure that the persons that we want to be in charge of it are in charge of it, and that there aren't any excessive expenses or problems that come up. And one thing I tell clients is, in addition to that, I think that how you do your estate plan can send a message to your family that you really care and that you took the time.
Nice.
Yeah.
You took the time to set things up in a way that makes their life easier and shows that you really care about them. And you don't have to be the richest person in the world, but you took the time to care to do that and to make sure that the right people are handling it, as I said, and that also would potentially minimize disputes, things like that.
Yeah,
so
I
think that's why it's important.
I love that perspective.
I do
Love that
too,
perspective.
because it's really not just about the assets themselves, but the person that is left behind that has to take care of them and that they are going to, handle appropriately.
Yeah, and I think as with many things in life, you learn that through when things don't go right.
Yes.
Right.
And we certainly deal with that a lot. And when you see people who didn't do the correct planning and then how that affects their family and the costs that can be involved and the headaches, then you really realize that if they had just taken a little bit of time to do it, a lot of that could have been avoided.
Exactly.
Wow. Yeah, definitely. That's a great thought.
So we hear a lot about probate, things going through probate or not going through probate. What does that mean exactly, and what are the advantages or disadvantages of probate?
Well, there actually are some advantages, which you don't really hear about too much, but probate is the process. Probate is the court that handles what happens when someone dies. It also handles guardianships and certain other types of things. So it's more of a general court that handles those types of things anytime that you're basically putting someone in a position of trust to handle assets or handle things for another person. Then that court has special jurisdiction over those types of things.
Okay.
But in the context of estate planning, when someone dies, if they own property that has to go through probate, then there's a process that you have to follow where the will gets filed if there's a will, and then you have to file certain forms and follow certain procedures to get those probate assets transferred or sold or whatever has to happen. And probate, I think, has become somewhat synonymous with some of the things that people don't want to do. You don't want to go through probate. You want to avoid probate.
Okay.
And the reason for that is that probate can be more costly.
Right.
It can take more time, and it can also there's ways to avoid it, and so that's where people think they want, assume they want to avoid it. And a lot of what we do in estate planning is helping people not have to go through probate if that's not what they want to do. Now, as I said, there can be, probate isn't in and of itself.
I was going to say, what's an advantage then? Why would anybody want their estate to go through probate?
Right. So whether they want to or not, the benefit of probate and the reason it exists is to make sure that things are handled properly.
Okay.
And because what you don't want is somebody taking advantage of the situation,
somebody
taking
as
money
in,
to
like
which they're not.
Family member,
A family member,
okay,
or somebody just involved in the.
It could be someone involved, or just a family member who takes advantage and takes more than their fair share, or pays themselves an excessive fee.
Okay.
There's all sorts of
things.
So
the probate could be the checks and balances sort of thing.
Probate court was designed to make sure that things are handled properly and that there's court supervision of it.
Okay.
But over time, as I said, there have been things have developed where you don't have to go through probate, but you can still structure things through trusts or other ways where you can still have oversight and some protection, but you don't have the same costs and time as you might with probate.
Going through a probate. Okay. Well, that makes a lot of sense.
That does make a lot of sense. And basically, probate is real estate specific. Is that, or are there other assets that would be covered by a probate court?
Right. So real estate is one type of asset that could have to go through probate, but it also other assets like bank accounts or personal property, household property. The way you determine if something has to go through probate is basically if the person who died owned it and and they haven't set it up in a way that would go in another way besides probate. So, for example, somebody could own it with joint with survivorship, which is very common with real estate. Then that doesn't go through probate because it goes through survivorship.
Okay.
Similarly, life insurance or retirement accounts, you name a beneficiary, and that is controlled by the beneficiary designation, which is a contract. Therefore, it doesn't have to go through probate. And then there's more modern methods, which have become extremely popular, are called transfer on death designations, which you can do for real estate now.
You keep hearing a lot about the transfer on death. Yeah.
Right. And those have become very, very popular now because you can do it for real estate or almost any other asset in Ohio. And basically, you just designate something to pass to somebody else at your death. It's almost like a beneficiary designation for life insurance, but it's for other assets.
Okay. For other assets. And
correct.
Not necessarily for the real estate.
Real estate.
Real estate's included, but you can do it for bank accounts, invest stocks and bonds. Just about anything. And again, it doesn't go through probate.
Right.
So
it's another
we do that quite a bit, and that's one of the tools we use to avoid probate. Has to be the right situation, and not, and then the final piece of the puzzle kind of is trusts, which I know we're going to talk about that more as we go. But trusts are a way to avoid probate because a trust is a legal instrument where the trustee holds title. So if the trustee holds title at the time of your death, then it's not going to go through probate because it's not in the decedent's name.
Got it.
So most commonly, we're going to use a combination of these things, not just one, to accomplish our goals, because some might be better for some things, some might be better for others. And, it has to all be coordinated.
So it just depends on the person's circumstances and their
what type of assets they have, their family situation.
Got it.
So
it's a bigger conversation. And a lot of different options, it sounds like.
It is. And I guess just to address real estate specifically, we used to, before transfer on death became available, we would very commonly set up a revocable living trust and transfer title to the
When did those all come into being? Because I feel like I'm hearing a lot about it now, but I'm hearing about it in the last year a lot, but is this like something like in the last year?
No. Exact date,
yes, please tell me.
No.
Is it the last 5 years?
Just kind of
3
a
years,
ballpark.
10 years? I'm just curious.
No.
Because I feel like it's just now I'm hearing about them.
As is often the case, things don't become common knowledge right away.
Yeah,
even
got it.
after they become available. I would say transfer on death for real estate became available maybe as long back as 15 to 20 years ago.
Oh, okay.
That may be a little long,
Okay,
but
okay.
maybe
It's just,
15
I don't
years ago.
know. It's on my brain.
But it
lately.
takes a while for things to catch on because lawyers don't necessarily start using things
Right
immediately.
away. That makes sense.
Because there's sometimes there's bugs to work out,
Yeah.
and you want to make sure, real estate
You don't want to be
You're
the
protecting
first.
clients,
Yeah.
so.
sometimes.
Yeah.
Yeah, and I know this was a big debate in the legal
Okay.
community when transfer on death for real estate was being discussed. Ohio wasn't the first state to do it, but because real estate attorneys, title attorneys had a lot of concerns because their life is making sure that things are done exactly right. I mean, you guys
Right.
know how title attorneys are.
Right.
So
right.
they were
And we appreciate that.
and it's a good thing because we want to make sure real estate titles are handled correctly and people really own what they think they own.
Sure.
So when it was proposed mainly by the estate planning community that we do transfer on death, there was some skepticism, is this going to lead to all sorts of problems and questions, and is it going to, so it took a little while for that to kind of work itself out. Now it's widely accepted, people understand it, and I would say that at least in our practice, and I think in many attorneys, transfer on death for real estate has replaced revocable trusts.
Okay.
You still might have a revocable trust for other reasons, but transfer on death has become much more common because it's easy, it's simpler, it's less expensive, and the other advantage is that what we used to run into with real estate with trusts is that if people were selling or refinancing the property, title companies wanted them to take it out of the trust.
Right.
Whereas with transfer on death, it's still in the individual's name,
Okay.
so there's no extra steps to do
Okay,
anything
got
like that. So there's some advantages to it. But like I said, we have situations where clients put it in a trust for other reasons. There may be some other reasons why that's a good idea. So
let me ask you this. If you have an estate already planned and you have a revocable trust, is this something that you should look to change? Or, I mean, since it serves a similar purpose, but this is easier, maybe less.
you mean if you have a revocable trust and
Yeah.
the property's already in it?
You've already set up your revocable trust, and now we've got these transfer on debts that make things easier in some manner.
So if I have a client who has a revocable trust but the real estate is not in it, so very often we'll do a transfer on death. It's called a desert affidavit. They used to call them transfer on death deeds, but then they changed it to affidavit. So you'll see both of those terms. And we'll often do that and name the trust as the beneficiary. So it ends up in the trust. It just gets to the trust through the transfer on death designation affidavit. Because because a lot of times you get a husband and wife and they say, well, we own the property joint in survivorship, so we're all covered. Well, what happens if something happens to both of you?
Right.
Then it's subject to probate. Well, we have a trust, but how's it going to get in the trust? It's going to have to go through probate. So we can do a transfer on death designation affidavit for a husband and wife, and that says at the second death it goes into the trust, but it doesn't have to go through probate. And why do you want it to go into the trust rather than directly to your 5 children? Well, for obvious reasons. If real estate or any asset passes to your children directly, they may be too young to receive it directly, or even if they're old enough, now all 5 of them, let's just use 5 as an example,
right?
Because I think it proves the point. Now all 5 of them are entitled, and they all have to agree on what to do with it.
And their spouses. If
And their spouses.
Oh, yeah.
I dealt with an estate.
Chris just went through this with a family estate, so there was a lot involved.
Right.
But it worked out fine, and fortunately,
You were lucky.
But I also hear stories of maybe some things that don't go quite as smoothly, but it just gets a lot of people involved.
Yeah.
A lot of people are involved, and if one of them is, the rebel and doesn't want to agree to anything, they could actually hold everything up. They could file a partition action and force a sale under terms that aren't favorable. They're-
This is why we want to
This
contact,
is-
they want
I'm
to
trying
contact
to
you.
scare you, Dana.
Set it all up
These ne-
correctly from the beginning. Call
These never
Chad.
happen. I'm just kidding. I'm just kidding.
You're
They
just-
do happen more than you
I
think.
imagine they do, right?
Yeah, and I've actually had situations where I talk to clients about doing a trust, and they say, well, you know, we got everything set up not to go through probate. Our kids are all old enough. We don't really need it managed through a trust. And we get through the whole conversation, and then I say, well, what's going to happen when the property passes to the 5 children?
Yeah.
Are they all going to agree? And then they're like, oh.
Oh, maybe.
So,
not.
so
Oh,
what a
gosh.
trust allows you to do is you name the trust, and then you name one of your kids or the 2 kids who are the most level-headed as the co-trustees,
Mhm.
and then they make the decision. Now you say, well, why should we favor them and give them the decision? Well, as a trustee, you're a fiduciary, so you have to act in the best interest of everybody.
Of all the parties involved.
Right.
Yeah.
So you can't just sell it to yourself for
Yeah.
half price, or your
Yeah.
cousin. And you have to be really careful how you handle it for everyone's best interest, get an appraisal, whatever.
Yeah,
But the point is,
You have
when
to
it,
follow the right
when it
steps.
comes down to the final decision, the trustees can do it, they can sign the deed, and everything can go smoothly.
Yeah,
As opposed to having to, chase everyone down.
Even the contracts, right?
That
Like
makes
from
sense.
our
Contracts,
perspective,
exactly.
when it's a
Yeah.
trust, we just need that one signature.
right.
Right.
We don't have to go to
Oh,
No, we
8
don't have
signatures
to.
or the 5 signatures.
Oh, yeah.
or the
Exactly.
whatever.
Correct.
Yeah.
Spouses.
Yep, so
Yeah.
that's really a
Yeah.
big advantage in many cases.
Yeah, got it. It's a lot of information.
Mhm.
So, one of the questions we get, and obviously when we're given these questions, I tell people they need
Defer them
to.
to an attorney.
I do, because you know what, it's not my decision, it's not my expertise or whatever, but what are some of the most common ways to hold title?
Okay, so.
You mentioned joint survivorship.
Right. Yeah, so, I mean, an individual can just hold it individually.
Mhm.
2 or more people can hold it. Joint tenants with right of survivorship, which means that at the death of one, it automatically passes to the survivor. You don't have to really do anything. There's a little bit of paperwork, but not a whole lot.
Mhm.
And then, but there's the other way that 2 or more people can own property is tenants in common.
Okay.
And so tenants in common means that they both own it, but their interest is basically separate from the other person. So if they die, it doesn't automatically pass to the other person.
Got it.
Okay.
And they would have to go through their
So if
estate, or
one
they
of-
could do a transfer on death designation affidavit for their interest,
Okay.
their half interest. So when you hear tenants in common, that's separate interest, not survivorship.
Okay.
Got it.
And there's other differences in terms of rights
Mhm.
between them, but that's really the most important one.
Okay, and that would make sense, I think of scenarios of seeing people who either are friends going in on a house. I've had that conversation with some people in the past year or so. Also, maybe some people who are not married who
Mhm.
are going in on a house together. I mean, and maybe they're, a partnership or whatever, but they're
Mhm.
not. And so covering themselves. And again, I always advise talk to somebody to make sure you're protected.
Correct. And the other way, of course, which we touched on earlier, was that you can have title held in a trust by a
Mhm.
trustee.
Sure. Mhm.
And so that would be another option. And one thing that's important to understand is if the deed is silent, it's going to be tenants in common. It
Okay.
has to say survivorship for it to
Okay.
be survivorship. But we occasionally will run into deeds that the client thought it was survivorship, but the deed didn't say that.
Oh.
Yeah, so you have to, verify it. Now, I would say almost in every situation I've seen where a husband and wife or a married couple are taking title, the title company or whoever is preparing the deed will just default to survivorship unless they're told otherwise. So
Okay.
it's
So
usually
that's
not an
more
issue,
likely.
but you do want to verify that.
Yeah, that's a good point.
Mhm.
Yeah,
Mhm. It's a lot to think about.
It is.
sure.
Definitely a lot to think
But,
about.
for a husband and wife, it's really, that's probably the easiest way to own it, survivorship. There's really not
Mhm.
any reason not to do that. And then, as I said, you can do a transfer on death designation affidavit. Both spouses would have to sign it, and it only takes effect at the second death.
Okay.
So if one of them dies, it still goes to the survivor, but at
Upon
the
the
second
second
death,
death.
then it goes under the transfer on death, which
Got it.
typically would be to a trust or to the children in some
Mhm.
cases.
Right, right.
Right.
What's the difference between a trust and a will then?
Okay, yeah, so, I mean, the way I explain it is a will or last will and testament, as it traditionally was called, is basically just a statement of how you want your property to pass at death, and it takes effect at your death. And it basically just says where it's to go. And you name your executor in it, you name a guardian for your minor children in it. And that's really what a will does. But again, anything that passes under the will is going to go through probate by definition. By definition, if it passes under your will, it's going through probate.
Okay.
So trusts became very popular and have become very popular for a lot of reasons, but one of them is that it allows you to avoid probate either by pre-funding it or by having assets passed to it outside of probate.
Got it.
The other major advantage of a trust over a will is that a trust allows you to manage property after your death for the benefit of your children or other beneficiaries, whereas a will doesn't do that. A will just says, here's who I want it to go to. A trust, because you're naming a trustee to manage it, you can be your own trustee while you're alive, but then you name a successor trustee after your death to manage that trust. They can then manage the property for the benefit of, for example, your children if they're too young, or if you have a child who has financial issues or health issues. You don't necessarily want that property going to them immediately.
Okay.
And I would say, a huge percentage of our clients that we work with will opt to do trust because of that reason, because it allows those advantages.
Would there be a need for both?
Well, you would always have both.
Okay.
Well, you'd always have a will if you have a trust, because, and in that case, we typically refer to it as a pour over will, because the will just says anything that we miss, because the goal is to have nothing go under the will, but if it does, which quite frankly is fairly common. We have lots of clients who don't want to go through probate, but you might not see them for 20 years, and then something ends up slipping through the cracks, and it does. So you got to have that will as the backup so the property can. But all the will says is anything that is not in the trust gets poured into the trust. So that's why we call it a pour over. Now. And the other reason you want to have a will, even if you don't have any probate assets, is obviously if you have minor children, that's where you name who you want to be their guardian.
Okay, got it.
The other reason is there could be other reasons that you need to have an estate open. You could have a legal claim that has to be pursued for wrongful death or for whatever.
So that
you could have. There could be other legal reasons, even if there's no probate assets, that you would need that. Now, if you don't have a will, you can still open an estate for somebody. The person is not called an executor, they're called an administrator, and they can still have some of the same powers. But, the will, obviously the will, it's better to be able to say who you want to do those things.
Okay.
So that's why you need a will, even if you have a trust.
Okay.
Now,
it looks like I need to review all
Well, now that's going to be one of my questions.
You're fine.
Is how often, how often should you be reviewing this?
Yeah, so, I tell clients every 5 years or anytime there's a major change in circumstances, whether it's financial, family, health, those are a good time to review it. 5 years, the one thing that we're running into now consistently is we recommend that clients update their financial powers of attorney every 5 years, because what we're finding is that banks and other financial institutions don't like old powers of attorney.
Okay.
So even if you're not going to do anything else, it's not a bad idea to update that. And it literally can be the same document. You just change the date and re-sign it. But
putting a new one into effect.
there's no law that says that banks that you shouldn't accept an old power of attorney, but banks and financial institutions for legitimate reasons can
prefer
become
to see
concerned.
Things more current.
Yeah, or a realtor.
And when should you begin? So you're like, okay, review every 5 years. Everybody got that review. When should you start to think about it?
Yeah, so I mean, once you turn 18, you have the legal capacity to execute a will or a trust or to do estate planning. And we actually have clients who we do estate planning for, or we, been clients for a long time who will call us and say, my child just turned 18. I want to get a will and a power of attorney in place for him, even though they don't realize they need it. And we'll do that. But I say,
if they don't have assets, I mean, is there a point to that?
Well, I think the parents kind of feel like sometimes they do, and sometimes they feel like, at least the power of attorneys, they want to make sure that they can handle things if something were to happen to the child. And I think that's smart. It's not a bad idea. And these are typically clients who are more affluent, who, have a little more attuned to that. But I would say there's no set date to do estate planning, but I would say that the life events that would typically dictate it, obviously, as you accumulate assets, getting married, having children. And I would say having children is the one that most people, that triggers most people.
I think that's when I came to you.
Certainly by then you want to do it. But even before that, if you have assets,
it's smart.
Right,
Once
smart to do it.
Assets,
and
the smart thing to do.
Right, and you got what you have. The other thing to understand is, even if you get married, you don't need kids, you're not sure you're gonna have kids, you can still do a will or a trust that says, I leave everything to my spouse, but if they're not living, I want to leave it to my children in equal shares. You don't have to name the children. You don't have to know how many children you're having. But that's what will happen if you end up having children. So if you do it when you get married and then you forget and don't ever touch it again, it's probably what you would have wanted. Chances are you probably would want to tweak it as you have kids and start to know which kids might be, more responsible than the others, and what ages you might want them to get it, et cetera. But
understood.
At least you have something in place.
Right.
And if you just have one, that makes it easier.
Well, it's actually funny you say that, because when a client calls and says, I have a really simple estate plan, I'm not married and I have no children. I hang up the phone immediately, because
that actually sounds more complicated to me.
They think it's simple, and they're like, this is just going to be real simple. Well, and sometimes it is.
What's not simple about it?
Well, because when you're married and you have children, the will says give it to my spouse and give it to my children. When you're not, I mean, I've had clients who they have 50,000 beneficiaries and charities.
Well, that's different.
Is it not, Mom?
I wanted to get
And then if they die, it's even worse, because in Ohio, if they have probate assets, you have to give notice to what are called next of kin. You have to give notice to anyone who's named in the will or who is next of kin under state law if they don't have a will.
So
if
they
didn't have a will,
then you have to
even if they have
next of kin.
You have to give them notice either
way.
Like
all the next of kin?
Well, next of kin is defined by law, but the point is, even if they have a will, let's say you have somebody who isn't married, doesn't have children, and then they name their cousin as the beneficiary. Well, when they die, if they have to go through probate, let's say they have 30 cousins or siblings, you have to give notice to every single one of them, even though they're not getting everything.
I get it. It's not that simple.
So probate can become much more difficult for people who aren't married and don't have children, because now you're going out to the diaspora of relatives all over the place, and it can get really complicated. So
that's crazy.
Oh my goodness.
So when they call and say it's real simple, that's the warning sign usually. It's usually the warning sign.
We know people in my household will be having conversations in the near future.
Call Chad.
I'll give you the scoop.
So Chris and I have been having a lot of conversations with some business professionals here recently about investment properties. So what if you have homes, properties that are investment? Is there a way, do we include those all in the trust, or is there a way to make sure that those assets are protected? Is it much the same way or different?
Sure. So as soon as we have a client who has other real estate besides their residence, then we start to talk to them about the best way to own that, risk management, liability protection, those sorts of issues. So kind of the state of the art, what almost everybody uses now, are limited liability companies,
LLCs, gotcha.
In the olden days, before LLCs didn't come around until the late 70s, and in Ohio, like mid 80s, they started to become common. I believe, maybe even after that in Ohio. But the before that, people would set up limited partnerships or just general partnerships, and those had some pros and cons to them when they wanted to own property. Or and in some cases, people would set up corporations to own real estate, which is usually a mess because
Okay.
yeah, because corporations are not a good way to own real estate. If you remember one thing from this podcast, whether it's a C Corp or an S Corp,
Yeah.
it's normally a really bad idea to own real estate in a corporation because of the tax consequences.
Okay.
You can have some real messy tax situations with that.
Okay.
But before,
Key takeaway.
Interesting.
but we
takeaway.
still see that, and
Yeah.
so sometimes we have to try to figure out how to
Have to deal
unwind
with
that.
it.
But today, it's pretty much a consensus that LLCs are the way to go, because LLCs came along because people said, why can't we have the best of both worlds? We want limited liability for everyone, like a corporation, so nobody can have personal liability unless they agree on it to sign it. But we also want it simple for tax purposes, like a partnership, because corporations are more complicated for tax purposes, as I just mentioned. So that's really with the genesis of LLCs, the best of both worlds. And you have a huge amount of flexibility in how you can structure them. You can have managers who run it. You can have voting and non-voting members, so you can have different control among family members.
Okay.
You can have flexibility in how it's taxed. You can put real estate in and out of it, generally on a tax-free basis.
Okay, real estate in and out of it. So like if I'm an investor and I have a lot of rental properties, that's.
You can just deed them into an LLC.
Okay.
And there's really no tax consequence to that. I mean, there's some nuances, but there's no like tax that you would owe.
Okay.
And similarly, if you decide to dissolve the LLC, in most cases, you're not going to have any taxes to do that.
Fantastic.
This is an oversimplification.
For sure.
Yeah,
We don't want to go too deep.
When you start getting into taxes, but that is one of the advantages. But so the bottom line is LLCs are really, sometimes I think clients might say, oh, their lawyers are like a broken record. They just tell you to set up an LLC. But the fact of the matter is that is really the best way in almost every case for a client to own it. And then it just becomes a question of how you structure it.
Got it.
And so again, if I have a client who is buying investment real estate or rental properties, already has them, I will and they haven't put it in an LLC, I will definitely counsel them to do that, because again, you have liability protection if you get sued for something that happens on the property. And you also have some benefits for estate planning, because let's say something happens to you. Well, now you can transfer the LLC interest through your trust or estate rather than the real estate itself. And you can have managers who are in charge of selling it or handling the rentals, instead of your family having to necessarily deal with that. So and then the other question is, do I have one LLC for all of my properties or separate LLCs?
Yeah, right. Good question.
There's no absolute right or wrong answer. We have some clients who will absolutely say, I want a separate LLC for every property, even if it's a two-family.
And I see that more with people who are flipping. If they flip, they establish an LLC for the property, more so than the rentals.
Yeah, I think so. And that sometimes that's because they will have different partners on different deals.
Yeah, that makes sense.
And keeps them separate.
Yeah, and it's $99 to form an LLC in Ohio. Obviously, you may have some attorney fees involved. It's usually not that much, but so there's really not a great reason not to have a separate LLC, because if you have more problem with one property, you don't necessarily want that to have bleed over to the other property.
Yeah, that makes sense.
Now, having said that, I have clients who've been doing this for a long time, and they have 5 properties in Ohio, and they might say, and it's too complicated. I just want to have the one LLC, and I'm not worried about it. But on the other hand, I also explain to clients, you could set up. The nice thing about LLCs, especially if you're the only owner, which is fairly common for investors, is you can have it can be a pass-through for taxes, so that it doesn't have to file a tax return. Everything passes through to their individual return on a schedule on a Schedule E, typically for real estate activity. But the benefit of that is I tell them, well, you have 10 properties, you could have 10 different LLCs. All that income is going to flow through to you on one tax return. So you don't have to file 10 different tax returns.
Yeah, right.
Or you could set up a holding company,
Mhm.
and that holding company could own all the different LLCs. So that now it's all flowing through to that. So there's just a lot of different ways. It's almost like you take a napkin and you start drawing, and you can do it any way you want it, and you can get pretty creative about it.
Well, it sounds like there are choices, there are options, and everybody's situation can lend to a different,
Absolutely.
A different scenario,
Yeah.
right?
Now, and again, but I also tell clients, LLCs are not absolute liability protection. You're protected from general liabilities that might occur with respect to the property, but you still want to have insurance and liability protections, and you're not going to be able to protect yourself if you have to personally. You might take out a loan in the name of the LLC, but most financial institutions, unless you're pretty substantial, a lot of them will require personal guarantees.
Okay.
So once you do that, you're going to be personally liable on the debt, but you wouldn't be personally liable if somebody slips and falls, or the property burns down, whatever.
Lots of things to think about.
Oh, I know. My brain is full.
Okay, sorry.
No, but I love it. I love when I just learn. I want to be the sponge.
Exactly. Yeah. So here's just a little bit of a switch, but looking at, contracts, if you're a landlord, there's all these, we talked about, it's not being very, very, doesn't cost that much to set up an LLC.
Right.
But there are these contracts out there on the web that are, tenant contracts. Are those a good idea, or someone who wants to do something like that for a lease on the internet? Are those wise, or
you're asking a lawyer?
I'm asking an attorney what his thoughts are about establishing, about using those types of contracts.
Look, I mean, if a client says I formed an LLC on my own, I'm not going to tell them. I mean, that's not a big deal. But
it's not okay.
There's two
it seems like it would be.
Just forming it. I mean, what I tell clients is the benefit to hiring someone like us, or to set up the LLC for you, is we can make sure that we think through all the issues and make sure it's structured right. Now they say, well, it's just me. Fine, I'm not going to argue with you, but especially if you have a partner, there are issues that you have to think about. The other benefit that some clients like is when you set up an LLC or a corporation, you have to name a statutory agent with the Secretary of State, and we do that as a service for our clients who are a law firm without charging them, so that when you look on the Secretary of State website, it says our name and our address, not their name and their address. And some clients don't want their name and address out there. So, and you don't really have to put it anywhere else. So some clients, just for that reason alone, like that. Yeah. But again, if they have a partner, especially, we can help them think through some of the issues with an operating agreement. Maybe some buy-sell provisions of what happens if one of them dies or becomes disabled.
I feel like a lot of times you don't know what you don't know until you have a problem. Maybe too.
You don't know, and same with leases. I mean, you can get a lease form off the internet or from somebody who sends you one. And again, I mean, if that's what you want to do, what I tell clients is you're not really paying a lawyer for a form. You're paying them for their experience and for spotting issues. Yeah. Ahead of time, rather, because once they happen, then it becomes 10 times more difficult to deal with it,
to unravel it.
So nobody likes to spend money. I get it, and we try to be very cognizant of that. And if we have clients who do a lot of real estate activities, we'll talk to them about, it's going to cost you a little bit more upfront as we get to know you and start to draft some documents, a lease or an operating agreement that works for you, but then the next 10 deals, it's going to be a lot less expensive because we already have done it. Right. So we're not going to just say, okay, this is this much just because it's a document. We give value for what we do.
There's a lot more that goes into it, and there's a lot to, the point of this conversation that you don't know until you take it that second step or third step or third or fourth question,
But whether it's estate planning or leasing or anything, again, a good attorney-client relationship, it's not for everyone. Some people don't, they just call a lawyer when they need them or after they have a problem. But the best attorney-client relationships are the ones where it's a long-term relationship. You trust them, they trust you, they know you're a trusted advisor, they can call you even if it's not a legal question.
Yes.
And a lot of times I don't charge clients. You're not going to release this part.
No, this part's going to stay,
I mean,
on the DL.
It would be bold.
Right. No, but I mean, sometimes clients will call me with a follow-up question or, something about their family or something that might come down the pike. And I'm happy to talk to them. I don't charge them because that's what it's worth it in the long run to have that relationship. The worst thing you can hear from a client is, hey, I didn't call you ahead of time because I didn't, I knew you were going to charge me. And then meanwhile, now you're gonna have to charge them $10,000 because they're getting sued over something.
To get out of something, right?
So again, it's not that I give away advice freely all the time, but I try to encourage clients to think of it a big picture, not just on a transactional basis.
Right. And you used one of my favorite terms, and it's a term we've heard recently, right? Talking to Kathy Lamb last time. Is that trusted advisor.
Right.
Yeah, and with Nick Bogan, the insurance. So we've had a lot of business professionals in these last few podcasts where it really is all about the relationship.
Absolutely.
Yeah. So really kind of looking at our listeners and some questions that we get, we thought we would just kind of throw a few things out there that.
Let's do it.
So technically we're switching gears into
real talk.
From the chat to the real talk, but we're going to keep chat here. We've asked you for some questions and we've had a few come our way.
Yeah, so we get some questions about power of attorneys because a lot of the time we're sitting at the closing table, we have power of attorney documents that have to be signed. What are the different types and what do they do?
So a power of attorney is a principal agency relationship. To get technical about it, you have a principal giving authority to an agent to do something for them. So you can have general powers of attorney, which is what we typically use in estate planning, where you say, I give this person, my spouse or my child, general authority to handle any financial transaction or a financial matter or a legal matter that might come up, because we don't know what might come up.
Right.
And those are again generally for if you become incapacitated later in life, or you have an accident or in a coma. If you don't have that, even if a spouse, they may have to go to court and get appointed as your guardian to be able to have authority to do that. So it could include financial stuff, or if you get injured in an accident, to be able to handle the accident. But if you have a good general power of attorney, that will all be covered in there, and generally that will give you what you need to be able to do. That's a general power of attorney. And some clients will come to real estate transactions with that and say, I already have this, I don't need to do a new one just for this. It covers real estate. The one thing that's different in real estate is anytime you execute a document using a power of attorney, you have to record the power of attorney, like you have to record the deed. So there's a little extra process there. So for that reason, a lot of times if the client has a real estate transaction that they need a power of attorney for, even if they have a general one, we'll recommend just doing a what's called a special or limited power of attorney just for that transaction. And that can just be like a one pager that says, I give this person authority, I'm going to be out of town, whatever. I give this person authority to sell this property, and then that stands alone, and that might just be an easier way for that to be handled.
Typically, I think what we come in contact with is that limited.
The limited, but I've seen both. Durable, is that
so durable?
Different?
So durable just means that it's effective immediately, and it remains effective even if the person becomes incapacitated. So with a general power of attorney in estate planning, you're almost always going to want it to be durable. There are ones that are called springing, which only become effective if the person becomes incapacitated. And those, we do use those sometimes, but those can have some disadvantages. So durable just means it's good for your whole lifetime unless you revoke it. Sometimes you'll see limited powers used for real estate transactions that are durable, but it's less important because those are usually short-term things where you're just needed for a month or something.
Got it.
And then the other category, general category, is healthcare powers of attorney, which most people are familiar with, either because they've done them or they've been asked to sign them at the hospital or the doctors. And those are standardized forms that Ohio and most states develop in association with the medical, the doctors and everybody in the hospitals. And those are where you give someone authority for health decisions, but those are a whole different category, obviously. So those are powers of attorney. I mean, but it's it's a way for you to voluntarily give someone some whatever authority you want to give them, so that, because otherwise, I mean, obviously they wouldn't have it, and if it becomes long term, you don't want to necessarily have to go to court and get appointed as someone's guardian.
And some of your expertise, or a lot of your expertise, lies in that elderly care type of situation.
Elder law,
elderly law. So is that go hand in hand with what someone should be doing?
So elder law has become a very hot growth area in the legal practice, because we have an aging population and there's more and more issues that people have to deal with as they age that are specific to aging. Estate planning, wills and trusts are obviously part of that, but that can be important at any age. Elder law really deals more with nursing home issues, long-term care issues, dealing with diminished or failing capacity, or how you might have to deal with guardianships or powers of attorney. So some of it overlaps with estate planning, but some of it's more specific. So that's an area that I do quite a bit of as well. And I may work. Usually, that type of work, you're dealing with the whole family, or at least the parents and some of the kids, because the kids are a lot of times the ones who realize there's an issue. They talk to their parents about going to see someone, and then the parents, obviously, you may have to make sure the parents are competent and they trust their children. It's not a situation where the children are just one child's just dragging them in to try to make sure they get everything. There's all sorts of cautions you have to go through, but the majority of the time it's a family type of situation where you're just trying to do what's best for the whole family and what the parents want. And sometimes it's, as I said, just making sure that things are set up so the kids can take care of things. Other times the parents want to try to preserve some of their money for the kids if they have to go to a nursing home, things like that. So that's become a much more of a growth area because of the times that we live in, I guess I would say.
Sounds like it.
So I do that. The other offshoot of that is what we call special needs planning, which is basically that comes up in two contexts. One is when we have clients who are doing estate planning who have children who have disabilities or other special needs, whatever it might be, autism or developmental disabilities. So they'll they realize, or they learn through going through the process. Children's Hospital has a lot of resources. They learn that there are ways that they can protect that child, both in terms of the child wouldn't be able to manage money if something happened to the parents, but also the children will most likely that they're cared for, and also the children most likely are going to be dependent on public assistance, government benefits. So special needs planning is basically setting up trusts or other things through the estate plan or other ways to protect the money for people who have special needs.
Got it.
And that's another area that I've done a lot with, and that has become people have become much more aware of it. And when I started practicing, you kind of heard about it, and there was kind of some general wishy-washy law about how it worked. Now it's everywhere, and the law has become very developed in that
Another reason to sit down with the trusted advisor, to sit down with a professional such as yourself and talk through all of your specific needs.
Right. And and that's what happens when I meet with someone. I always tell people the first meeting is by far the most important when I meet with the client, whether it's an estate planning or a business, because that's where I learn what's going on and figure out what needs to be done. And so it's really important to have that meeting, not to try to shortcut things, because you never know what you're going to identify as an issue and that they may not even have thought about, and that becomes the most important thing that you end up doing.
Right.
So
Exactly.
Excellent.
I've
Well,
got
that's
one
been a
final
lot
question.
of, okay, this has been a lot of
Okay,
information.
sorry
It is
if
a
I
lot
talk
of
too much.
information.
What's your,
Not at all.
no,
I just
good,
had-
valuable information.
Oh my gosh, yeah, no, there's kind of an offshoot, and it doesn't
Yes.
have to do with estate planning, but this is another question that was presented by one of our listeners, and it has to do with disclosures, and we've talked about
Oh,
disclosures
yeah,
quite
yeah.
a bit.
Everybody's favorite subject. Right?
Everybody's favorite subject. So scenario came up where a buyer purchased a home and, nothing on the disclosure about any issues. 6 months later, they had a flood in their basement. They came to find out from neighbors that situation has been recurring in the home
Mhm.
over time. And of course, the disclosure was clean. Do they have any kind of recourse? What can that homeowner
Sure.
do in that scenario? And I know, again, this isn't
How
your
much time do we
area.
have left?
Just give us a little snippet of
Can we
what
do
you
a
would
double feature?
recommend. We could. We
That's
could.
it. Why not? It's this podcast. You can do whatever you want,
We
right?
can do whatever we want.
Exactly.
What's your recommendation? What are
well,
your thoughts?
So let me preface it by saying I don't do real estate litigation, which
right.
is really what that would fall under.
Right.
We have other people in our office who would handle that. But the way I look at disclosures is that every other area just about of buying a house is buyer beware. You do your inspection,
Right.
you see what you see, and then if you accept it, you close, you're done. The property disclosure is the one area where the law has said these things are important enough and would be hard enough to discover on an inspection that now we're putting the burden on the owner to disclose them. And if they don't, now
They're in trouble.
you have a smoking gun, for lack of a better word, that they didn't. Now, as you said, sometimes not only do you have to know that there's a problem, but you have to know that they knew about it. And so usually the neighbors are the best intelligence for that.
Yep.
So if you get to that point, really, then it'd be, then I would say talk to a lawyer. I hate to punt, but most lawyers will talk to you without charging you, just generally about something like that. I don't want to speak for everyone, but the reason I say that is you really have to assess how much are the damages, how good is your proof going to be, and is it going to be worth spending the money to go after them versus just unfortunately dealing with it.
Yeah.
I'm not saying it's not worth it. I know of cases and situations where there were significant issues and they sued the seller and been successful. And so it's certainly a possibility. It's like anything in the law. If they violated the law, if they committed fraud, or they didn't do something they were required to do under the property disclosure law, they're liable. But like with anything, it comes down to proving it and how much it's going to cost you to do it.
Right. That makes total sense.
Right.
And those things are great considerations. So
right.
On that note,
and a good question.
It is a good question. It is a very good question.
Well, we want to thank you for joining us today. Our small business shout out goes to Chad Levin from Heyman Law. And tell our listeners how to reach you.
Oh, okay. So we are located in Montgomery, as I mentioned, and I can be reached by phone at 513-909-4031 or by email at csl@Heyman Law. That's my initials, CSL@Heyman Law. And I assume that either be information on the website or podcast, but and happy to talk to anybody anytime about anything. So
thank you.
You never know where it might lead.
Wonderful. Thank you so much.
Sure.
Hopefully all of you have learned as much as we have. Thank you for joining us today. And this has been House and Home Chat, Real Estate Real Talk with Dina and Chris.
Thanks, everybody. Take care.
Bye.